Hey friends, come on in and type in enough is enough. Okay, we're going in a new direction today. It is Sunday, February 15th. I hope you had a terrific Valentine's Day. And for those of you who weren't able to do something on the actual day, do something today. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with clients nationwide at McBean Law, where, of course, we believe in freedom now. But today, I want you guys to type in enough is enough. We're going to talk about a new lawsuit that is now open and available for individuals who are caught up in this awful, unfair, and unlawful pause on your immigrant visa. And you know that this terrible, terrible pause on immigrant visa has been in effect for, I want to say we're now in the third week. It's awful. It's separating families. It's delaying people from coming to the United States to begin working. It impacts the employment-based immigrant visas as well as the diversity visa and also family-based visa for the green card. So we're going to talk about it. So come on in, type in enough is enough. Enough is enough because the pushback now has to be very strong and it has to be togetherness. So I'm going to share with you what you can do to get started with this process. And for those of you who are on my email list, you got an email from me last night letting you know that the process is now open, and this is the 75 country ban. However, at McBean Law, we will only be litigating this case for nationals from 52 countries, and I'm going to get into those details momentarily. I see folks are coming in saying enough is enough, enough is enough. Yes, that is what is in my heart, in my mind, and in my spirit. Enough is enough. Let's push back, let's fight, and let's show the government that you can't just do this to people. Here you are following all the rules. You've paid your fees. You've filled out all the applications. Some of you have waited years. I mean, a long time to finish this process, years. And you're at the very tail end of this process. And then, just like that, overnight, without warning, without any clues or signal, or notice, the government has changed the rules on you. And there you are sitting in your country thinking, well, what's going on in the US is not going to impact me. I see, yes, there are a lot of changes happening in America these days, and it's coming in fast. It's the zone has been flooded by a lot of news every day. Things are happening in America, and these are very unusual times, but surely it's not going to impact me. So that was the thinking that maybe a lot of you had. And then you woke up to the news that your case that is slated for an embassy interview, here you are with your interview notice coming up. You wake up to the news that the rules have changed on you. And there is this indefinite pause in place, and now it changes everything. Because for some of you, you started planning, you started preparing for the transition. You might have even given up your job. Things changed for you, and now you're stuck wondering, wait a minute, when is this going to be over? Is it really going to be a 60-day pause, or is it going to be something more long term? What is going on? Well, now is the opportunity for you to band together through litigation that our firm has opened up for 52 countries. And let's go ahead and put on the screen here the link to our website. And I'm going to have this link on for the remainder of this live session. This is a link on our website at mcbeanlaw.com/75 countries pause, because that's how people know this. They know it as the 75 countries pause. But again, this is our map here of the 52 countries that we're onboarding for at this time. And I'll explain to you guys why we have only decided to target 52 countries. Freedom, now someone says, I don't know how to get started or if I should get started. So watch this live session so that you'll get some more clarity on what's going on. Now, what I'm going to do now is pull up our website and share with you what we're thinking and who can participate in this, because it's not open for everyone who have a case at the National Visa Center for the immigrant visa through the DS-260 process. This is not open to everyone from these 52 countries. There are some parameters here. Friends, the process will start with an online automated process with you filling out the forms and uploading proof, the evidence that we're asking for from you, and paying your fee. It's also $1,500 for this lawsuit as well. And your submission will come to us at the firm. We will review your documents. You will get an email from us letting you know that, number one, we've received your submission. And number two, you'll get a second email indicating that the legal team, our litigation team that I've put together, a special team that is working through our federal litigation practice, we're now reviewing. I'm on that team. By the way, I am on that team and I have a lot of legal work to do now, thanks to these two lawsuits. So I'm on that team and I'm reviewing your eligibility forms as well as your documents that you've sent to us. And I'm also giving instructions to my colleagues to contact you and to let you know that we are missing this or we need something additional. So you will get an email from us letting you know that your case, your file is under review. If you do not meet the qualifications as we're reviewing your case, we will let you know so, and you will be refunded in full for the fee. If you do not, but however, you should understand that we have an earlier process on our website through this link that will disqualify individuals who, based on your responses to those first few questions, we will know whether you're disqualified or not. All right. So that's basically how it works. After we receive all of the submissions and everyone submit their applications by our deadline, which is March 18th, we will prepare the complaint and get it filed within 30 days. That is my goal. And that is what I've told our litigation team. Within 30 days of us closing onboarding, we've got to file this. So now let's go in to our website, which provides a lot more information. And as you're coming in, certainly continue to type in enough is enough. This lawsuit is through our LIFT practice, Litigating Immigration for Freedom today. And again, the deadline to join, I'm sorry, I might have messed up on the date with the deadline, but the deadline to join this lawsuit is March 14th. March 14th, that's this deadline. What's going on? Why are we doing this? We're doing this because on January 21st, the State Department announced a pause on immigrant visas for 75 countries. We, as I've mentioned, believe that this is not lawful, because certainly when our immigration federal laws and rules say that when an individual is before a U.S. embassy for the immigrant visa, the embassy official must review that application on a case-by-case basis, make a case-by-case determination about whether to approve the applicant or not. However, what's happening through this policy that the State Department has put in place, they're applying a blanket approach, despite the fact that individuals are qualified for the visa. The embassy has no choice but to say no to them. And that's not how the law works and what it says. So we have honed in through litigation on 52 countries. Those countries include Albania, Algeria, Barbados, Bahamas, Brazil, Cambodia, Cameroon, Bangladesh, DRC, Democratic Republic of the Congo, Egypt, Ethiopia, Ghana, Georgia, Jamaica, Iraq, Kazakhstan, Jordan, Lebanon, Liberia. There are so many here. I won't go through all of them. Pakistan, Russia, Rwanda, St. Lucia, Thailand, St. Vincent and the Grenadines, I'm sorry. So I just know it as St. Vincent, okay? Uganda, but my apologies for the speech problem. St. Kitts and Nevis, Rwanda, Uzbekistan, and several others, Kuwait, Guatemala. These are the countries, friends, that we're going to allow into the lawsuit. And let me jump back on the screen and explain why. And we do have an FAQ on our website explaining why as well. The reason why you do not see a country like maybe Haiti or Nigeria on this list, which we really would have liked to include, is this. It was a strategic decision that we made based on the fact that the travel ban countries cannot be part of this particular litigation because the U.S. Supreme Court has given the executive branch broad authority over national security and foreign policy considerations. And so the travel ban is not something that we could tackle in this one because the highest court in our country gives so much authority already to the executive branch to put in place travel bans. However, this particular pause on immigrant visas um, is connected is not connected to it also includes, of course, travel ban countries, but we had to eliminate those travel ban countries because the what we're asking in this lawsuit is that the government be compelled or forced to consider your application on an individual basis based on the merit of what you've shared with the US Embassy. And the embassy must say yes or no to you based on your eligibility. And we're compelling that action rather than have you swept up in this indefinite pause that is really hurting you and hurting your family and your and companies here in the US as well, of course, are going to feel it if their foreign worker cannot come here through the green card process. Now, so that's why. So we're compelling that final action on your application so that you could get your visa and enter the United States. But if you're in a travel ban country, and by the way, some attorneys who are doing this process will not tell you this. They will just say, oh, everyone can come in, everyone can join this suit. But I don't operate that way. I have to be transparent with our clients to let them know what can and cannot work. And so we made the strategic decision that the travel ban is still going to stand in your way. Okay, if you're from a travel ban country. So that's the reason why some of those other countries, the travel ban countries, are not connected to this. However, what we can do for applicants from travel ban countries like Nigeria and Haiti, we can still, on an individual basis, bring your case to the government through a waiver, a national interest waiver, if we find that you have a strong enough case to have a waiver submitted on your behalf. That's what we're doing for travel ban countries. But for everyone else, they could join this lawsuit if they meet our qualifications. And so, with that being said, I'm going to go back to our website and take you through the qualifications to join this lawsuit. Again, I've mentioned it's $1,500 fee to join. If you have derivative beneficiary family members, like a spouse or your children who are unmarried and under the age of 21 who will be immigrating with you, they could join this lawsuit as well. And it is still just one fee of $1,500 for the principal, the benefit, and the beneficiaries. One fee of $1,500 per family. You must be an applicant of the DS-260 immigrant visa application. All right. Type in enough is enough as you're coming in. Enough is enough. You're the applicant of a visa application DS-260. You are a national of one of the 52 travel ban country. Immigrant pause. We'll make the correction on our website. It shouldn't say travel ban. We had to do this in such a hurry over the last few days to make this happen for you, but we'll make the correction on our website today. So you're a national of one of the 52 countries that are subject to the immigrant visa pause. Number 3, your case has been documentarily qualified at the National Visa Center, which means that you've received your notification or an email stating that you're at that part or stage in the process of documentarily qualified, and you're now just waiting on an embassy interview. This is just the minimum. The minimum is documentarily qualified. Some of you already had gone to your embassy interview after January 21st and been given a refusal letter. You obviously can enter into this lawsuit if you choose to. Others have been had been interviewed. You were interviewed in 2025, maybe, and you were placed in administrative processing 221G, and now you're ready to go to, finish up your process in 221G, but this is in place. Well, you are being harmed, and if you choose to, you can join this lawsuit as well. But everyone, of course, must at a minimum be documentarily qualified. Number 4, you have at least one of the following evidence or proof that you could upload during your onboarding process. Number 1, you have your documentarily qualified email or screenshot from the Visa Center. And when you're in this documentarily qualified stage, what it means is that you're now waiting on an interview date from the US Embassy. The ball is really in their court to give you a date. So you are really at the tail end of your process. Despite the fact that you might have been waiting for months, you're still at the tail end of your process, and the ball is in the court of the government. And that's why this kind of lawsuit is going to, if it's successful, compel the government to act on your case and give you your interview date. Or some of you have a visa refusal letter that was issued after January 21st, letting you know this is the reason why your visa could not be approved because of this pause. And then, like I've said, there are those who have a visa refusal letter indicating that you were placed in 221G administrative processing, and you could upload that letter. It could have been issued to you at any time, even in 2025. You also must agree to the terms of this lawsuit. There's a fee agreement that you will sign during your automated process, and then pay the fee to join. And then lastly, you cannot be a plaintiff in a similar lawsuit against the State Department. We will close out this process, this onboarding process on March 14th. We're giving you 1 month to join this lawsuit. At the bottom of the page on our website, there are litigation FAQs that I think you should read, including, who can join, why isn't my country on the list of 52? Can I join this lawsuit if I have an approved I-601A waiver or the I-212 waiver? And I'm going to open that up and show you that the answer is yes. Yes, you can. If you're physically here in the United States and you have an approved I-601A waiver or the I-212 waiver, and you're going through the consular process at the National Visa Center, certainly you can join. But again, your case must have reached as far as the documentarily qualified stage. An argument can be made that you're being harmed and hindered from obtaining your visa because of this our terrible policy. Then we have other FAQs here about whether your personal information will be made public, and the answer is no. There's a way through the lawsuit. We'll be able to protect who is part of this lawsuit and who could see what documents we file versus in addition to documents that the government will respond to after we file this case. So take a look at this FAQ, FAQs. This is not a class action, okay? Just like our 39 country litigation against USCIS, that's not a class action. These lawsuits that we're working on will only benefit those who are part of our lawsuit. We're only acting on your behalf, not the entire class. So please take a look at our website if you'd like more information about how to be part of what we're doing, because we are at the stage where we've said enough is enough. Okay, enough is enough. So with that being said, I'm going to answer some of your questions and then we're going to get back to our Sunday. Let's get back to our Sunday. How much is the fee? It's $1,500 to join this lawsuit. Let's get the map up here, back up on the screen. 1,500, and it's 1,500 per family, so long as it's just the spouse and the unmarried children under 21 who are connected to your case. And by the way, those individuals, your children and your spouse, they of course will have their own DS-260 application process, so they will need to you will need to submit their proofs if you'd like them to be named in this lawsuit as well. Enough is enough, and freedom now, because we're not letting go of that. So thank you, Reveal 12-0, for saying enough is enough, and freedom now. They go together. They go together. Um, okay, Evangelist Borner is asking, where can we go to do, what can we do to get this waiver? The waiver is based on, by the way, with this waiver, I believe you're talking about the national interest waiver, which is what we can do for travel ban visa applicants only. Okay. We're going to be looking at the making an argument to the government. There's nothing specifically like, okay, you must go and fill out a form or anything like that. It's really a process that the government really has a lot of darkness around, because I don't think they want a whole lot of people to just go out and start filing an application called a waiver. It really has to be a write-up that will go in with your case and making that argument to push you forward. But it is a hard argument to make that you or your spouse or your children have an it's in the national interest of the US that you guys come in and or come together as a family, because this government does not value family unity. So we will be honestly evaluating candidates, individuals, for this type of argument about the national interest. So get a consultation in with us. And if you've already met with us, we've already evaluated things on your behalf. It was my expectation initially that we could include everyone in this, but of course, the more we strategized about it, we didn't feel comfortable, or me, I didn't feel comfortable. I'm just going to be honest with you guys. This was my decision. I wasn't comfortable with the idea of us taking your money if we could not get you that end result. Like I said, other attorneys are doing that. You could join their lawsuit if you choose to. We're not doing it that way. We want to make sure that we're targeting those who we could really get the result for. Thank you. Enough is enough. Enough is enough. Thank you. Haiti is not part of this lawsuit that we're filing. Okay, it is a travel ban country. Our government has made, and yesterday we had our free webinar in Haitian Creole to a lot of people who joined our free webinar yesterday. One of my attorney colleagues who speaks Creole was in the meeting and helping with the webinar. And one of the things that I said to the Haitian attendees at that webinar is that the government is trying on all sides to really squeeze Haitians from many different ways. And it's so cruel that even Haiti is on this travel ban list. There's no real justification for that, yet they've done that. And I think it's, of course, discriminatory. So So it's important that if you're a Haitian national here in the United States and you're going through a process at USCIS and your application is held up due to their 39 country adjudication pause or hold, we have a lawsuit that we're onboarding for. We've extended it, and that deadline is February 18th. My goodness, that's on Wednesday. So some Haitians have already joined, along with people from all across the world, the world. Who are nationals, Iran and all these countries are banding together folks are banding together to say enough is enough. All right, let's go. What about the adjustment of status application? That is connected to the 39 country USCIS lawsuit that we have going as well. You could go to our website at McBean Law. What I'll do, let's go back to, I'm going to pull up our website one more time and I'm going to show you how to navigate things. Okay, let's see if I could get this right. I'm going to just let's get rid of this map from the view on our website. Even if you start on the home page, okay, even if you start on the home page, you will see, let's go to the home page. Let me just scroll up here and see if I could get, okay, so we're going to go home. Okay, so you go home, McBeanlaw.com, and you just scroll down and you'll see our lift information, litigating immigration for freedom today. You hit the join our lawsuits, and after that, you will be on our litigation page and you will see immediately the current cases that we're working on, the lawsuits. And the first one is the USCIS adjudication pause with the deadline of February 18th to join that lawsuit. So you click that link and there you go. And then you'll also see our State Department 75 country visa pause, in which it will take you to our page and you'll see more information and be able to join. Let's just, maybe I'll just go through a little bit of the process here with you. On each page, guys, there is our plaintiff eligibility form. That's what gets you into the automation process, and you'll have to answer pre-qualification questions. We just ask a few in the beginning, and depending on how you answer these questions, you may or may not be able to continue with the full process. So this is how we're doing it. It's a very simple, easy process. Let me just jump back on the screen here. So just go to McBeanlaw.com and you'll be able to navigate around. Okay, let's see. All right, great question. What about those who already technically had their interview at the USC embassy or consulate, but they need the I-601 waiver, and that waiver, of course, is pending, and that individual is still outside of the United States waiting. Okay, so what we will, for individuals who are in 221G, you are in 221G because you've been refused the visa based on the fact that there's this inadmissibility problem that only an I-601 waiver can tackle. And so I would say that if your waiver has been approved, then it makes sense to join a lawsuit like this one. But if you're waiting on that I-601 waiver, and let's say you're from a country like Jamaica, and Jamaica is not a travel ban country, that USCIS has decided to hold up the processing of your application. Well, if Jamaica is, if that's the case, then you're in a different situation. Some people, the ones who we will allow in are only those who already have that approval, and the ball is not in the court of USCIS waiting for a 601 decision, because USCIS is processing that 601. The key here is this. Number one, the ball must be in the government's court, and the government has made the decision they will not move forward with whatever that application is. That's not the case with this I-601. if it, certainly it depends on what country you're from. If you're from one of the 39, then they're holding it up, and in which case, then it makes sense to consider the other lawsuit that we have going. Okay. Thank you, guys. Thank you. I am from one of the banned countries. What is the requirement of the lawsuit? So I assume you're referring to this immigrant visa pause. The requirements, I've already covered them. You might have been around. You may or may not have heard me cover them. I don't know. I'm just going back to the comments and taking it in order. But again, you must, at a minimum, have a case at the the National Visa Center that was at least documentarily qualified. You've passed that, minimum requirement, and you are from one of the 52 countries that I had noted above, and you have proof that your case was documentarily qualified, and you have an interview. You've already had an interview but refused, or you're already in 221G, and you're being held up. You're just being held up. Okay. Thank you. As I've mentioned, it is refundable. The fee is refundable if you do not qualify for the lawsuit. Okay. I had an adjustment of status interview in December 2023. I'm from Haiti. I haven't heard anything else from USCIS. Most likely your case has been swept up, unfortunately, Lynn, under their 39 country pause. So you could go on our website and see the requirements to join that lawsuit as well, to get things moving. Do you know anything about the lawsuit to protect U and T visa applicants from deportation? I think a decision is supposed to be made this week. I do not know about that. I have not been following that litigation, and I don't know who filed it, whether it was an organization, a nonprofit uh, organization that banded together with other organizations and law firms, or whether it was a privately filed lawsuit by a law firm. I don't know. I'm not sure what's going on with that. But what I do know is that I do know that at least one attorney has they're onboarding. They've been onboarding for a good while now for uh, plaintiffs to join. I believe it's their T. I don't know if U visa applicants are connected to what they're trying to accomplish. They've been, it's been slow trying to get these individuals who are impacted by potentially being detained, despite the fact that they have a T visa application in and a bona fide determination. I think U visa might be part of what they're doing, but I'm not plugged in on that level. Thank you. Thank you. Also, just keep in mind too that on Instagram and Facebook, on Instagram, when you see my post about these lawsuits, you could just comment whatever the word is, visa. For this particular lawsuit, you could just comment visa, and you will automatically get the links to learn more information and to join. For the other 39 country lawsuit, you type the word lift and lift, and you will automatically get the link DM to you on Instagram. On Facebook, we provide the links, and you could click on them on Facebook. Hello there. Good afternoon. Good to see you guys. Freedom now, and enough is enough. Are interviews for the immigrant visas still on? Yes, they're having folks go all the way up to the very end through an interview, and then they hand you an exit letter that says that, unfortunately, because of this pause, we're not going to give you your visa today, and have folks walk away puzzled. So yes, they are taking the steps to get folks all the way up to their interview and then refusing them, which we think is wrong. It's unfair to you to do it that way. What should we expect on Wednesday, the 18th? Well, I mentioned the 18th because that's our deadline to onboard plaintiffs for the 39 country adjudication pause at USCIS for those who have an application pending at USCIS. So that's where the 18th came into play here. Okay. Let's go down. Enough is enough. I see your enough is enoughs. Thank you. You've got to be documentarily qualified at the Visa Center in order to join this lawsuit. How about 221G 75 country news? That's what we're discussing here. The pause is still in place. So we're onboarding for our multi-plaintiff lawsuit to help people and to push back to the government and say that this is wrong. You can't, they pull a string and then all of a sudden your entire life, your plans, your everything is upended. And should that happen? I don't think so. I don't think that's right. Rules are rules. When you're playing by the rules, you're following the rules. And then when you get this close, they yank it out of your opportunity away from you. That's that's just really that's bad, right? There's no other way of saying it. That's awful. So we understand that your life is being impacted and if you choose to, you could push back, okay? Thank you. Thank you, Lyft. So I see that folks are typing in Lyft on Facebook, and my moderator, who is moderating on Facebook, she's sharing the link, and it's also available in the posts, any post that we have out there on Facebook. Thank you. All right, guys. So again, we have two important dates coming up. March 18th is the deadline, the onboarding deadline for the USCIS lawsuit that we're working on. For those of you who have an application held up at USCIS from one of those 39 travel ban countries. The second big date is March 14th, and that's our onboarding deadline for this the State Department's pause on immigrant visas. You can go to McBeanLaw.com's website and see more information about both lawsuits. And this is 100% online. It's an online process. So once you begin that process, just expect that you're going to have to answer quite a number of questions. Be patient with the process, and especially as you're answering questions about the hardship that this is causing you, we really would like your strong, good details. Okay, that's going to help a lot. So if your job opportunity is on the line, talk about that. There's a number of things that are happening to people. So uh, share your hardship on that form and answer the questions accurately. Let's see. Also, please be careful and use only the links that we share with you through our DM and that you see on our website. If you're uncomfortable with the links that you get through DM, as you should be, go to our website at McBeanLaw.com and click on those links so that you could feel a lot greater confidence that you are really connecting to McBean Law and no one else. So please be careful of internet scams and social media scams. When I get offline from a live session, I am going back to my life and my affairs. I am not DMing you and messaging you. I respond to comments on social media. Most of the time I try to jump in and say something. But through DM, trust me, it is not me. My colleagues are in the DMs responding to some questions. So from time to time, yeah, obviously you will get responses, but it will be from my colleagues. It's not me. So please do not share your personal information with anyone on WhatsApp. There are a number of big scams going on right now on WhatsApp in my name. It is not us at McBean Law. We're not interacting with you in that way on WhatsApp. We have a very rigorous process to work with us, and you will know it if you've been through it. You will know it. You will know that you've reached us. You're going to have all these callbacks, and you'll speak with a real lawyer. You will speak with people in the billing department. It's a process. It's a team effort. So be careful. And you could also have a video meeting with us to see us. You could come to the office to meet with us in White Plains, New York. We make it available for you to meet with us in many different ways. So please be careful. One other thing to note is that if you receive any voice notes on WhatsApp that sounds like me, like, oh, it's 1 o'clock in the morning and McBean is sending me a voice note about this case and it sounds so intelligent and it's like me. I listened to one last week that someone who was scammed of all this money sent me. It does sound like me. It's AI. It's AI, guys. Wake up. It's AI. It's not me sending you legal advice by voice note or on WhatsApp. I don't do that. I don't touch it, not even to family members. So please wake up and follow our process that you see on our website only. Thank you. And with that being said, guys, it was great having you today in this live session. Share this with other people. I will be back before you, God willing, tomorrow, Monday, at 1 p.m. Eastern Time for our Freedom Now live show, where we will be talking immigration news because things are happening. And I'll answer your questions at that time. Thanks so much for being with me, guys. And I will see you in the next one. Let's see. Bye-bye.